Thank you.
And next we have, and again, I'll just apologize to everyone, Peter either Nicita or Nikita Nicita. Thank you very much. Now he will be followed by Michael Nowacki. Mr. Sakita, thank you for coming, and take your time. I believe, do we have written testimony from you, sir? Yes?
I did provide it.
Okay, thank you.
Good afternoon to the panel, and thank you for providing the opportunity to speak on these important matters.
Can you speak up by any chance? I'm so sorry.
Sure. I'm certainly grateful for this opportunity, and just as important, I'm glad that this issue has risen to this level and has prompted change. This is an excerpt of a letter with names withheld written by the court-approved therapist and provided to the GAL in my case. The mother is shrewdly aware of his vulnerability and is an expert archer. My brief experience with the mother left me with the impression that she is the architect of the majority of their perpetual feuds. In my professional experience, I often see mothers with this mother's degree of influence tell their children to go to school when they are anxious and avoidant, so they do not develop a pattern of sanctioned school avoidance. Healthy mothers instruct their children to have parent-child relationships with the estranged parent, even when the two parents no longer love one another, knowing that the love between a parent and child is different from what became corrupted between the individuals who were the source of their creation. This mother doesn't promote that type of alignment between the children and their father. As highlighted above, and in prior sessions between Son and Peter, it is clearly evident that the mother does not believe in or support the concept that the biological father has a right to regular and unfettered access to their children. This letter was written in September of 2011. The letter went on to recommend a normal parenting plan of weekend and weekdays overnights, something that I enjoyed for many years with my children. It also provided monetary penalties if the mother continued to violate access. This therapist's ability to make a recommendation was stipulated several months prior to this letter to the GAL as part of a court order for me to reunify with my children through a therapeutic process. The GAL, Attorney Tom Ferrantino of Manchester, Connecticut, has been on my case since May 2010, a year and 4 months prior to this therapist's letter. At the time of the GAL's appointment, I was seeing both my children on a regular basis. As I stand before you today, I have only seen my children for a few hours since May of 2011. Despite the therapist's recommendation and despite various court orders providing a parenting plan, my family has not seen my children for over 3 years. The GAL has been unwilling to address the apparent parental alienation and the mother's unwillingness to abide by court orders and the parenting plan. The GAL has willfully ignored these orders, neglecting his role and duty to assess the best interests of the minor children. When brought to the attention of the judge, I was told the GAL had no obligation to adhere to a therapist's recommendations, despite the orders for the therapist to make such a recommendation. Based on my experience, and not just limited to this short testimony, GALs are protected. They have such extensive immunity to the point where they have the ability to exploit parents, and judges support and endorse these actions. There is no accountability in the activities of a GAL. A parent has nobody to turn to, nobody to complain to. There is no supervision, and no evaluation of a job a GAL is doing, or in many cases not doing. Often there is no accountability and noncompliance of court orders when one parent is unwilling to abide by those orders. Per Dr. Roeder, parents' noncompliance can be detrimental to the child and possibly that child's relationship with one parent. I believe that the panel's questions to Dr. Roeder on how to deal with a parent restricting access was appropriate. However, given the criteria of best interest of a child, it is the GAL's responsibility to bring to light to the court if a parent is noncompliant. However, the courts are not holding that person responsible or accountable, nor are the courts holding or requiring GALs to follow Connecticut Statute 46B 56C, best interest of a child. The court is creating some of the problems that have prompted the need for this task force by backing the GAL's lack of willingness and ability to bring a parent's noncompliance to light. Sadly, this exploitative practice by many GALs is driven by greed, the benefit of increased billings, and is done at the expense of family relationships, college funds, and the well-being of the children they are being paid to protect. With extensive immunity and nobody for parents to turn to, many GALs continue is highly unethical practice. Something that was mentioned during the panel's hearings, post-judgment matters drag on. There was no case management. There was no consistency and no controlling judicial personnel to monitor a case.
Mr. Nicita, could you summarize your
Sure.
remarks, please?
Although some of my panels may disagree, I think there should be some type of summary to each file. So when you go back to court, you don't have to rehash, and a judge will have the ability to understand what's happening in the case. As far as shared custody, I certainly support it. I think if both parents are willing and able to care for a child or children, as we heard from Dr. Roeder, children positively thrive when they maintain full and healthy relationships with both parents.
Thank you. Let me ask a question. What specifically did the GAL not do that you felt he should do?
Well, in that specific example, there was an order that we should go to therapy to reunify. There was obviously a breakdown in the relationship for many different reasons. The letter was sent to the GAL. I entrusted the GAL to follow the court orders, as I usually do myself. And I believe the therapist was putting his best foot forward to make sure that the relationship stayed intact or were built upon. And the GAL basically, I think because agreed and wanting to continue the case, put the letter in his back pocket, even though there was a court order.
I'm sorry, I'm not understanding. So what should he have done then that he did not do, in your view?
I believe he should have brought the letter to the court, and obviously there were some issues going on per the therapist's letter, and I think he should have brought it to the light of the court and enforced the parenting plan or recommendations that the therapist was providing in the letter. It's my feeling that the GAL did not do that because he wanted the case to continue.
Did you have a copy of the letter?
Yes.
Were you able to bring it to the court?
We had gone to court, and there were orders put in for therapy again, and subsequent orders for visitation, but those orders are currently not being followed again.
Okay. And the reason I ask is, the GAL has no enforcement powers, is not a judge, can't enter orders,
Right.
it can't file motions.
Understood.
So I'm having difficulty understanding what your feeling is about, what he should have done.
What we've been through before the court, subsequent to that letter, certainly, because that was 2.5 years ago. And I don't think he's been factual or truthful, and I don't think he's taken the recommendation seriously. Whether he's biased or not, I certainly think he is. I ultimately think he wants cases to continue and doesn't have the best interests of the children.
Can I ask where you represent it?
At that time, I don't recall. I've had several attorneys. I currently am not represented.
I was asking because that was, if you were represented, it would have been your lawyer could have got that into the court, and if not, I can see where you're coming from. That as a pro se, it would be hearsay, and it would get something that, well, even if you had an attorney, but the attorney could have subpoenaed someone, but if you're pro se, it might have been easier for the guardian ad litem to get him.
Actually, I do remember I was being represented. We were asking for a recommendation from the GAL and was not providing it. We had been through court several times. Again, there was other orders that were in place that were not adhered to. And then eventually the letter became stale, which, in my opinion, is the GAL's fault because it wasn't a letter to me.
Did the GAL ever file something called a request for a status conference to take that issue before the court?
That currently is in place and was supposed to go by the end of this month.
Okay. Ms. Vernal.
And if I could add, sometimes when you get before the court, there are a lot of restrictions on what you're allowed to say and what you're allowed to do. This is an open forum. That's not always provided. Again, I brought it up to the judge October of 2012 about this letter, and I basically expressed my frustration. And as I stated in my testimony, she said he basically doesn't have an obligation to take the recommendation of the therapist. I'm paraphrasing,
Yeah.
but
Were there a lot of continuances, or, I mean, did it
There
take a
were
long
often-
time to get things going?
there often are. One of the problems that I was having was the judge was a little bit fed up in my case because this has been going on since 2001, and we had been before that judge in 2004. So she was a little disgusted that we were in front of her again. She had stated that she was going to call my daughter into chambers, and being protective, I did not want to do that, and I was actually disputing with my own attorney because that was his suggestion to follow that, and I said, I'm not going to do that to my daughter. I haven't seen her in 3 years, 2.5 years, whatever it was, and I didn't want to put her through that.
Thank you. I'm sorry, Ms. Veronal, I jumped in.
Actually, you brought up something that I was going to ask. So I think in 2011, there was one form that they could submit to the court whenever something was, they needed to bring attention to something to the court. And then was it in 2012 that the other form came out that if court orders are not being followed, if things are affecting the child adversely, there's a form to fill out. So I'm really curious why this GAL, when they received that information from the child therapist, why he neglected to even do anything with that. So did you ever ask him why he's not bringing that back when it first came about and not now in 2013?
I think my case is beyond the point of orders. It's quite evident in my case that one parent is not going to abide by the orders. I've tried to communicate. There is currently an order to try to sit down with my ex-wife's husband, and that order is not being followed. So it doesn't matter what we try, and that's the issue that I'm having with the GL. He's not recognizing that no matter what orders are put forth. But to answer your question, I don't remember in 2011 if there was a certain form or a procedure. I received that letter in a discussion with the GAL that I had asked for because at the time I hadn't seen my children for a few months. The therapist brought that letter to the meeting. It took me 12 emails to obtain that meeting with the GAL. Prior to that, he was ignoring me. So really at the time he was not even addressing the issue of me not seeing my kids. So doing anything about it, I think probably fell low on his list as well.
How much was he charging an hour?
I think he's approximately $300 an hour.
And do you remember how much you spent in total? Approximately?
I want to say with him I've roughly spent about $15,000 just myself. I will say overall, and I lost count over the last 12 years, I've spent somewhere between $150,000 to $175,000. Assets have been depleted. I borrowed from friends and family. At one point, I was incarcerated for not having the ability to pay a GAL. My girlfriend had to then go out and collect money from her family and my family to try to get me out of jail at the time. And nonetheless, I was there for 3 days.
So were you ever accused of being an unfit parent?
No, and that's the sad part. I was actually very close with my kids, specifically my daughter. My son and I have a different relationship. Not that there's any lack of love there. He's somewhat aligned and close with his mother, which is great. But I don't think that closeness should be at the expense of another parent.
Okay, thank you.
Any other questions? Mr. Weissmuller?
Would it be? I'm sorry. Would it be helpful in your situation, and some jurisdictions do this, where the GAL is appointed with specific duties, given a specific timeline? In fact, in the jurisdiction where I worked, I had to publish my dollar per hour rate, so that if someone looked at it and said, that's too much, I want someone else, they could do that within the first 5 days. But would it help to have specific timelines and then a specific report, so that if there's a task to be done, there's a return of a report that might be used for purposes of mediation? Otherwise, make sure that it comes in soon enough so that if you know that the report will help you in trial, then you call that person as the GAL as a witness in a hearing to seek some kind of remedy. Would that be helpful to you?
I do think that would be helpful. If those procedures or orders were stuck to, When we had a court order in 2011 for the reunification and possible recommendation from the therapist, there was a callback date. And then you just enter another orders or additional orders, and possibly those aren't adhered to. So it's somewhat of a snowball effect. I don't think there's anybody at the end of the line holding GALs accountable or saying, okay, the time is up now. It's been 6 months or it's been a year. When we were in court and I did complain to the judge, she actually said to the GAL, I think your function should be on an as-needed basis. Well, that judge is now rolled out of the Hartford court system into a different system, and he's back on the case, at hearings and or discussions with family relations, where he really isn't saying too much or nothing's come out of those. So there's been some inconsistencies, and that's why I suggest, although some people may disagree, that somebody needs to control a case, whether a judge or a case management person, because it is somewhat open-ended and there is no accountability.
Yeah, well, during this time, it sounds like you're saying, and I don't want to put words in your mouth, it sounds like you're saying that he's there maybe getting paid but not doing anything in particular right now?
Certainly not. He did call for a GAL status conference. But as I said to Ms. Verano, I'm not quite sure if orders would help, and I think he's been willfully ignorant to the fact of parental alienation, that one parent and one parent will not follow orders. I'm not quite sure if he's not equipped or he just has not made that assessment. And it is my understanding from reviewing best practices. Best interest of child, that it's up to the GAL to assess certain criteria, and I don't think those criteria have been properly assessed.
Sir, when he filed that request, has it been before the court? Did the court do anything with that request?
It has not. We are due at the end of this month.
It's still not before the court?
That status conference was just filed in November or December, so it got continued once or twice, once actually because I was out of town working, but another time due to his schedule conflict. So I'm hoping, and I've actually spoke to the opposing counsel, and I believe we are on for the end of this month.
Okay, thank you. Any other questions? Thank you very much for your
Thank
time
you.
and your story.